Then number two, then the court is going to appoint the personal representative. Your personal representative named in the will is just a recommendation. A lot of times wills get contested. That's a problem for another time. Now you're in probate court, and did you know that this is open to the public? Anyone can go down the courthouse, pay a small clerk fee, and see your entire case. You got court costs, you got attorney fees. The statute says probate fees are 1 to 3% of the assets, plus additional cost. Plus, if it's a contested case, you can charge additional attorney's fees. What does that even mean? It means we add up all the assets which have to be distributed through the probate court case in a basic formal administration. We then take 3% of the value, or a minimum of $6,000 plus the filing fee, publication fee, and any other court costs. Now, under some circumstances, depending on the assets and how long ago they passed away, you may be able to file a summary administration, which is significantly cheaper. So do you think it makes sense to spend an hour or two of your life to get your estate planning done so that your loved ones don't have any court costs or attorney's fees? All you have to do is take action. Don't procrastinate. Do it now. Also, wills don't really allow for any asset protection. What if your daughter inherits the money and she's got a lien or a judgment because she had a car accident or she has credit card bills? Or what if your daughter inherits the money and then she gets divorced 3 years later? Do you want half of that money going to somebody you didn't mean for to go to? What if you give your money to your daughter, then she gets divorced 5 years after you died? He gets half your money, then he gets remarried, then he dies, and half your money ends up with some stranger. That's money that should have gone to your grandkids. There's no control from the grave with a will. How does a trust-centered plan work? Well, first of all, you can designate a trustee or a co-trustee. You can have multiple backups like a hierarchy. You can designate who's in control. If you don't have a loved one maybe, or you don't have any family members, you don't have children that you want to put on there, that's fine. I have solutions for this. We can use corporate trustees. We can help you fix your problems no matter what your situation is. Also, you don't have to prove the trust in court. There's no probate court other than filing a notice of trust. It's a private process. People can't see what you're doing and what you set up for your affairs. It's all private, no court costs. If you want to protect your spouse, if you want to protect your loved ones from unforeseen divorces, unforeseen car accidents, you can plan for it in advance. You need to structure your affairs to protect your loved ones. And the simple way to do that is with a properly structured trust document set up by an expert. Don't go to LegalZoom and click a few boxes and get a trust that will not fix your problems or may not be structured correctly for your state. Also, they will not help you fund it. They will not help you pick the type of trust needed for your specific situation. There's many different types of trusts. You got a revocable living trust. What does revocable mean? Revocable means you can change it anytime you want. You're in control. You're the trustee. You can make changes. You can name your successor trustee. You can avoid probate, unnecessary court costs, and attorney's fees. You're not going to see a trust get contested. I've never seen anyone contest a trust. I've seen many wills get contested. Wills get contested all the time. And what do you want? What if you want to preserve the assets for a surviving spouse or your heir? What if you want control from the grave? What if you want little Johnny to get the money, but you want him to go to college, or you want him to have some income when he retires? You can actually structure that to have what we call control from the grave if that's your goal. Another type of trust is irrevocable. Irrevocable means you cannot change it. Why would someone set up an irrevocable trust? Well, you might have some assets that you want protected from lawsuits or creditors. You might want to protect your money. Have you ever heard someone say, I don't want the nursing home to get all my money? There's 4 ways that you can avoid a catastrophic Medicaid spend down. There's 4 ways that you can make sure the nursing home doesn't get all your money, but we're not going to go into that today. You know, something we do for our clients is we explain all that and we help them make smart choices to protect their money. But that's not what this webinar is about today. Now, one of the 4 ways is estate planning, but one of the challenges you have to stay under certain thresholds. There's a 5-year look-back period for this one method. Please don't listen to the webinar tonight and run out and set up an irrevocable trust. A little bit of knowledge is a dangerous thing. You don't know what you don't know, and you just need a little help. When you come to meet with me and become a client, I'm going to take the time to educate you, sit and help you fill out your transfer forms and beneficiary forms. There are several types of irrevocable trusts. Another is a special needs trust or supplemental needs trust. And there are more than one type of these trusts too. What's a special needs trust? There are lots of people that are receiving government benefits. They're getting a check because they qualify for a government benefit. But you know what? If they came into a bunch of money, inherit money, the government check stops. If there's someone that you want to benefit and transfer wealth when you die, but you don't want their benefits to get cut off, you need a special needs trust. So if you have a child or a loved one, you need to set up a third-party supplemental needs trust for them where your assets will go upon your death. We can help you with this. We do a lot of these, and the purposes of them is to protect the beneficiary and still gets the government check. You're basically appointing a trustee that can help them with things like health, education, maintenance, support. You want to be able to help that special needs person, but you don't want to mess up their benefits. There are many types of revocable and irrevocable trusts, more than we have time to discuss. Another probate avoidance tool is a ladybird deed. What you do is maintain ownership and full control of your property, keeping your homestead exemption, and transfer your property free from probate directly to your beneficiaries upon your death by recording the death certificate. Some other basic documents you need are a durable power of attorney, a medical power of attorney, HIPAA release, and a will. What's a durable power of attorney? It's a document that only matters while you're living. The power of attorney is null and void once someone dies. Do not put your child's name joint on your bank account. Put them on as payable on death or in trust for. Why should you not put your child's name on your bank account or house? Well, is your child married? Yes. Does he drive a car? Yes. Does he file a tax return? Yes. Is it possible his health could decline? Of course, anybody's could. Well, if you put your son on all of your stuff and he gets divorced or has a car accident or the IRS is coming after him or he has medical bills, someone will be coming after his assets and he's on all your stuff. Guess who else has money they can come after? You. Sometimes jointly titling an asset might make sense. A lot of times it's a really bad idea. There's tax implications. For example, having your son on your house blows a tax benefit. He's not living there with you or paying bills. He may even own another home in Florida. Now, when you die, your son would have capital gains taxes. A durable power of attorney is a document used during your life. For example, I have several bank accounts. I have company, corporate accounts. Well, my business account is not joint with anyone. It's a company account. One day I was busy, so my son ran up to the bank. They told him he can't do the deposit because he's not on the account. He called me. I said, "You have a power of attorney." Read that last paragraph. Basically, it said he could act as if I was physically present. Now, there's different kinds of power of attorney. He has my immediate power of attorney. He's authorized to help me right now, but my brother, who's a CPA, he's my backup. He does not. What if my son is incapacitated? What if he predeceases me? My brother's the backup. Do you think my brother can walk into the bank, close my bank accounts, and take off to Mexico? No, he's got what's called a springing provision. It only takes effect when certain criteria have been met. What's a medical power of attorney? It's a legal instrument that designates a person to make medical decisions when you can't do it for yourself. For example, if you're in a coma, you've had a car accident, you're at the hospital, and the family's gathering around, and the doctor says, "I can't help you." Have you ever heard of HIPAA? You're heard of the HIPAA, and doctors are paranoid about getting sued, so they will often shut down. They won't share information. You need a medical power of attorney, known as a designation of healthcare surrogate, for a couple reasons. One is you need it to allow for the medical professionals to talk to your loved ones without having to go to court. For example, if my 19-year-old is in a car accident and they transfer him to another hospital and I go to the old hospital and say, "Where's my son?" They literally don't even have to tell me where they transferred him to because of his private medical information unless I provide a healthcare surrogate and HIPAA release. So what is a living will? It's a document that addresses whether you want them to pull the plug and other what conditions. Do you all remember Terry Schiavo? She was on life support for about a decade. Her husband said her wishes were to be taken off of life support. Her parents said, "No, we want her to be kept on the feeding tube." She was brain dead in a coma, so they all ended up in court. Do you know if Terry just would have had a living will that never would have happened? All this stuff takes an hour or two to fix. It just takes an hour or two to fix. It's simple, it's easy, it's inexpensive, but Terry obviously never got around to it. And sadly, her family ended up in a horrible court battle. It took years and ended up at national news. Don't do that to them. Take action. Fix these problems. You want these documents to speak for your wishes when you can't talk. In conclusion, we will talk to you about your estate planning goals over the phone for 15 minutes at no charge. If you wish to come into our office, there is a consultation charge for the appointment. I'm going to tell you exactly how to fix your estate planning issues based upon your individual circumstances and assets. What should I bring to the appointment? Your existing will or trust, any power of attorneys, usually a recent tax return, some copies of your investments, your 401k, or your brokerage accounts and life insurance policies. To recap, what is estate planning? Ultimately, it's the accumulation, preservation, and distribution of your estate. We need to make sure you're good in all those areas: accumulation, preservation, and distribution. So give me a call.